Dogs don't discriminate, and why that's bad for the police. How's it going? This is Alex Zouzlas, author of the book Courtroom Confidential. I'm going to tell you a story about a dog, a Lyft driver, the driver's passenger, and a whole lot of drugs. What you're going to hear is a very creative argument made by the defendant's lawyer. The trial judge rejected the argument, but the Court of Appeals said it was a great argument, a winning argument. So the defendant won on appeal, right? Stay tuned to find out. The case I'm going to analyze is Ford versus State, a January 2025 decision by Florida's 5th District Court of Appeal. I provided the citation to the case in the description to this video. Just a reminder, I'm not giving legal advice. I'm simply analyzing a situation which commonly occurs. In this case, a warrantless search of a car made after a drug dog alert, and I'm speculating as to how the situation can be handled by a smart lawyer. The story starts with the background of the case. Then it moves to the defendant's argument and the trial judge's ruling. Next, I'll discuss the Court of Appeals analysis, and then I'll reveal the appellate court's surprising ruling. Last, I'm going to speculate as to how the situation could be handled by a smart lawyer. So let's start with the background of the case. A lot of lawyers think they can't do anything about a warrantless search based upon an alert from a drug-sniffing dog. That was true before Ford. Since Ford, that's not necessarily true anymore, as there are instances in which lawyers can successfully challenge such searches. One such instance was discussed in Ford. The defendant in Ford was a passenger in a Lyft rideshare car which was stopped for speeding. According to the cop who stopped the car, the defendant appeared nervous and agitated. That caused the officer to ask the Lyft driver for consent to search the car. The driver refused, so the officer called for a drug-smelling dog. The dog was trained to detect the odor of cannabis and a variety of other drugs. After the dog arrived, no word if the dog was driving, it walked around the outside of the car twice, conducting free air sniffs. A free air sniff is the dog walks around the car, smells the air is free, hence the term free air sniff. The dog alerted to the presence of illegal drugs during the first pass by trying to jump on the car and breathing rapidly with his nose up in the air. During the second pass, the dog stiffened, stared, and planted himself next to the car, which, according to his handler, was typical of how his dog alerted to drugs. The police searched the car and found 7 mason jars filled with marijuana and baggies containing crack, ecstasy, and meth. So you're thinking this guy's screwed, right? Not so fast. The police also found a debit card in the defendant's name and a bag sitting next to the defendant. Not only that, the Lyft driver told the cops the guy had the bag when he got in the car. So this guy's really screwed now, right? Not so fast. Let's talk about the defendant's argument and the ruling by the trial court. Here's the argument his lawyer made to the trial judge. It's a very creative argument. Good argument. Since a drug dog can't tell the difference between hemp, which is legal, medical marijuana, which in Florida is legal, and other forms of cannabis, which for the most part are illegal, when the dog alerted, there was no way of knowing whether any of the drugs in the car were illegal because the dog couldn't tell the difference between drugs that were legal and those that weren't. Without other evidence that there were illegal drugs in the car, the dog's alert alone didn't provide probable cause for a warrantless search. The trial court, and I'm sure the dog, disagreed. So the court, not the dog, denied the motion to suppress. On appeal, though, the 5th District Court agreed with the defendant's argument. Here's the Court of Appeals analysis. In its analysis, the Court of Appeal talked about the plain smell doctrine, which it said is a logical extension of the plain view doctrine. Plain smell cases are cases in which probable cause to conduct a warrantless search is based solely on a drug dog's alert. In order for there to be probable cause, the incriminating character of what the dog smells has to be immediately apparent to the, this is the language the court used, percipient witness. In this case, that would be the dog, which, when you think about it, is kind of a weird thing to say because the dog can't be a witness since it can't talk, but that's what they said. A dog also can't be a witness because it can't tell its right paw from its left, so they can't be sworn in. If you disagree, let me know in the comments. While a drug dog can differentiate between a steak and a chew toy, it can't tell the difference between the odor of different drugs, some legal, some not. Consequently, the police have no way of knowing whether the dog detected an illegal or a legal substance. In reaching its conclusion that plain smell doesn't immediately indicate the presence of an illegal substance, the court pointed out that certain types of cannabis have been legalized at both the federal and state levels, which makes it rough for a dog to figure out exactly which type of cannabis it's smelling. The court also noted that probable cause can't be based on hindsight, that is, what a search ultimately does or doesn't turn up. Thus, in a plain smell case, the alert alone can provide the probable cause needed to justify a warrantless search. So did this guy win? No, because the Court of Appeal upheld the trial court's decision on the good faith exception to the exclusionary rule. What's that, you ask? The good faith exception applies where the police rely in good faith on then binding appellate law. Back when the Ford search occurred, the cops had PC to search based on then controlling case law. In other words, the holding in Ford that the police didn't have PC to search based solely on the drug dog's alert couldn't be applied retroactively, so the defendant in Ford was screwed. What you got to remember, though, is from January 7th, 2025, when the Ford decision came out, if you've got a cannabis case that's based on a search made solely on a cannabis-smelling dog's alert, you can get the court to suppress all the evidence the police find during the search, as well as any incriminating statements your client made during or after the search. There's 3 caveats that are important to remember. First, the initial stop has to be lawful. If it's not, that's actually a good thing for you, because then you'd file a motion to dismiss in addition to the motion to suppress. Second thing is, the dog alert has to be the only basis for the search. This argument won't work if, for instance, the police see drugs in plain view before the dog sniff. Third, the dog has to be trained to detect cannabis, and there has to be cannabis in the car. If the dog is trained to detect other illegal drugs, but isn't trained to detect cannabis, and there isn't cannabis in the car, then this argument isn't going to work. Those are my thoughts on a warrantless search based solely on a police dog alert under the facts of Ford. I think this is a really interesting topic, so comment on it. Comments always generate interesting discussions. Subscribe to my channel, and if you're a lawyer, consider hiring me to research legal issues and draft pleadings under your supervision. My contact information is below. Thanks for watching, and I'll see you next time.